jurisprudence. When we are talking about the schools of jurisprudence, we have to specifically keep in mind that jurisprudence is the skill or knowledge of law where we have to specifically talk about and see that how we are seeing the law, whether the law is for the benefit of the society or not. If I'll talk in the words of Salmon, then I'm talking that jurisprudence is the name given to a certain type of investigation into a law, an investigation of an abstract, general, or theoretical nature which seeks to lay bare the essential principles of law and the legal system. My dear students, by this definition of Salmon, I mean to say that jurisprudence is basically a certain type of investigation in which we can understand that why there is a necessity to study, why there is a necessity to investigate the picture, the present picture of law, and where the law would take us for in can take us there in the future. So this is the lame definition. With this, I'll tell you, these schools of jurisprudence studied the law of that particular society and talked about the basic nature that with this particular kind of society, law should be as it is or law ought to be. If I'll talk about jurisprudence, it says that there are 5 particular schools of jurisprudence, which are philosophical school, historical school, realist school, sociological school, analytical school. The 5 1. Jurisprudence is the hypothesis and investigation of law. It basically gives us the cause and idea of law. It simply says that it is a comprehension, differs from individual to individual, society to society, perception to perception. Everybody has a different perception of law. So this particular talk, this particular article, this particular presentation today will talk about the 5 schools of law. I'll be starting with the first school, that is analytical, imperative, or positivism. In this particular school of thought, we have seen that it is also known as Austinian school, since its methodology and everything is set up by John Austin. It is also called as an imperative school. Why? Because it has its regards that law as the direction of the sovereign. We all know that Professor Dias has given this methodology as positivism. It is also a certain topic of a school, that is a certain law. The analytical school basically picked up unmistakably the quality in the 19th century. The methodology was mainstream, positive, and exact truth be told. Austin has propounded this theory of positive law and which has been established by Bentham. So this particular, see, the terminology itself says that analysis, imperative, and the positive. So this particular school of thought gives us the analytical and positive picture. Let's study how the professors have given their theories. Jeremy Bentham can be said as the author of this particular analytical school. In one of his books, he dismissed the principle of natural law and expounded the rule of utility with logical accuracy. See, the word analytical says, is the same, that we have to analyze that with a logical accuracy, that what is going on, why there is a necessity to do so. The previous arrangement with the law, all things considered, with the last arrangement with the law as it should be. Later on, Austin gave the primary, precise, and extensive treatment on this subject, and he said that analytical positivist methodology, and because of his work, this particular theory is known as analytical school, and he is also known as the father of the analytical school. Later on in his theory, the Kelsen talks about that, which is also known as pure theory of law. He suggests that law must stay free from social sciences like brain research, human science, social theories, etc. He said that that it should be an investigation of law which will be pure, as it will, carefully sun all powerful moral, mental, and sociological components. So what Kelsen has talked about this theory, he said that it should be, it should be a pure theory of law. It should be different from other social sciences. It should be an investigation of law in which we will carefully research and carefully see that what is moral, mental, and sociological components. Excuse me. Later on, someone surrenders the endeavors to locate the general components in law by characterizing jurisprudence as an art of civil law. He indicated, that there is not at all like general component in law, since it is the exploration of the law of the land, then it should be for this specific state. That is also civil law. If I'll talk about the nutshell of this theory, it says that this is the analysis of the origination of the civil law, the investigation of different relations between civil law and other types of law, it is there. The investigation into the logical game plan of law, it's there. A record of legal sources from the which the law continues, it's the main this thing. The investigation of the theory of obligation, and it also talk about the origination of the legal rights and obligation, which is the main part of the civil law too. Then it says that to research such legal ideas as property, contracts, people, their aims, and so forth. So this theory is